So you found yourself showing up for jury duty, and you don't think the defendant did anything wrong, but you definitely think he violated the law. Maybe his gun was the wrong shape. Does justice require you to vote to lock him in a cage? Let's talk about it.
While the host of Fuddbusters is a lawyer, he is not your lawyer. If you pay him, maybe, either way you slice it, the video that you are about to watch is not to be construed as legal advice.
So I was talking with my friend Matt at CRS Firearms the other day about this. He just put out a video discussing the topic, and he invited me to cover it too. I think it's a great idea. The country is pretty solidly split as to whether gun laws are a good idea at all. So aside from fighting through the political system, is jury nullification a good solution? I think it's part of a greater solution, and that everybody should know about the inherent power of juries to nullify laws they think are immoral. You guys hear me talk about our English system of law quite a lot, and how I think it's the best system out there. It's certainly not perfect, but it's likely the best. One of my favorite parts about our system is how much discretion is built in. In more rigid systems, the law is the law, and any violation, regardless of circumstance, is punished strictly to the guidelines. Even if you think our system is the same way, it isn't designed to be like that at all. Every player in our system, from the politician who voted for the law, to the investigating officer, to the charging prosecutor, to the jury, have an oath and a duty to do justice. And justice is something that exists independent of the law. Juries are an essential part of our justice system, ensuring that common members of the community have a say in the administration of justice. Unlike judges, though, the jury has the power to ignore the law in order to achieve justice in any given case. So you might have heard of a thing called jury nullification. It's where, generally speaking, members of the jury know that the defendant is guilty, but choose to acquit him anyway, either because they believe the law is unjust, that the prosecutor misapplied the law, that the potential punishment is just too severe for the circumstances, or they just plain like the defendant and think he's cool. Let me start with this. There is absolutely nothing illegal about jury nullification. It is a feature, not a loophole, of our legal system. It's not illegal to talk about, and definitely not illegal to apply. The Supreme Court has ruled that the power exists and is perfectly legal since the 1895 case of Spaff v. U.S., but has not required judges to inform juries about its inherent power. The problem is getting everyone to know about this power without messing with a jury that's already been impaneled. This power is strengthened by the fact that if jurors morally disagree with the law, they can't be punished for the verdict that they render, regardless of how upset the public or the judge is. Also, if the jury acquits a defendant, he can't be retried for the same crime. That means that if a jury finds a defendant not guilty, the state is stuck, and there's no way for the prosecutor to bring the case again. That said, you might have heard of instances where people outside of courthouses were arrested for trying to inform jurors about the concept of jury nullification. This reflects an interesting issue with the way the court looks at the First Amendment. For one, there's no doubt you have the right to talk to people about jury nullification. It's another story as to whether you have the right to do it wherever you want. There's a really awesome organization, the Fully Informed Jury Association, that works to educate people on these concepts. If you want to get involved, following their guidelines should generally keep you safe. That said, these cases mostly involve people trying to educate people right outside of the courthouse, as against local orders restricting pamphleting within a certain number of feet of the courthouse steps. It's been held that the government can restrict speech activity in certain locations if it's done in a neutral manner. Now, I think this is a load of garbage, but it is what it is. The courts have held that the government has an interest in controlling order in the immediate vicinity of courthouses, and especially inside of courtrooms. In the vast majority of states, judges will not allow lawyers to raise the concept of nullification to the jury, and won't provide an instruction to the jury about their power to nullify. Courts have struggled their way through this distinction in several ways. For example, in the 1996 case of Mouton v. State, after the defense asked the judge to instruct the jury of their power to nullify, the court wrote, Although jury nullification is a recognized aspect of our jury system, there is no constitutional implication that would require a trial judge to instruct the jury on nullification. It's no secret that members of the judiciary are openly hostile to the concept. For example, the Kansas Supreme Court referred to the power of nullification as such. Although it must be conceded that the jurors in a criminal case have the raw physical power to disregard both the rules of law and the evidence in order to acquit a defendant, it is their proper function to accept the rules given to it by the court. And I mean, this is kind of natural when you think about it. After all, many judges, after they've been on the bench for so long, kind of become automatons. They become disconnected from the morality of the particular defendant, of the particular situations, and want to see things or have things seen as they do. Kind of a strict checkbox approach. The fight here is mostly on where you can actively attempt to educate people on their power to nullify immoral laws. In Michigan, a man was convicted of attempting to influence jurors when evidence showed he was specifically targeting jurors from a specific trial to give pamphlets to, as opposed to just randomly handing them out. So the fine line is just generally educating people on the concept versus specifically targeting jurors to try to influence their decisions. I think it's a great thing that members of our community should all know about. And we should talk about jury nullification with all of our friends. In my opinion, all laws restricting the simple possession of arms, or really the simple possession of anything, are completely immoral, as the simple act of having something doesn't harm others. I'm of the opinion that where there is no victim, there ought be no crime. That said, if you do decide to study jury nullification, you should know that if the prosecutor even gets a whiff that you're thinking about nullification, any one of them worth their salt would strike you from the jury pool. That's why many nullification activists advise people not to talk about the concept once they're inside the courtroom. When the state asks you questions, it's generally probably best practice to answer them with the minimum amount of words very specifically to what they asked. Right now, the concept of jury nullification is being pushed hard by opponents of drug prohibition, but its history in this country is much deeper than that. In 1735, John Peter Zenger was charged with printing libelous materials against the English governor of New York. Despite the fact that he very obviously did it, he was found not guilty. It was also very often practiced in cases brought under the Alien and Sedition Act and in prosecutions against people who were accused of harboring escaped slaves in violations of fugitive slave laws. During the Prohibition era, the practice of jury nullification was used heavily to nullify prosecutions of people accused of violating alcohol control laws. In the 1930s, juries nullified alcohol convictions as often as 60% of the time, making prosecutors not want to bring them and helping pave the road to the end of prohibition. I see no reason that jury nullification shouldn't be a part of gun rights advocacy. Where somebody has harmed nobody else and is accused only of the simple act of owning a gun, I think he deserves no punishment. This definitely isn't an independent answer to all of our concerns, but I think the people serving their purpose as a guard against injustice is something everyone should be in support of. Let me know what you think. So that's all I've got on this subject. I just want to say I really appreciate you guys watching and subscribing. If you want to support more than that, I've started up a Patreon and a Subscribe Star. I've added benefits like a patron-only podcast, a Discord, and surely more to come. This kind of support will help enable me to make more content more regularly, something I'd really love to be able to do. There's also a link to the Fuddbusters stickers in the description below. Thank you all so much for watching to the end and for your support. I'll see you next time, or if you become a patron or subscribe star, I'll see you on the Discord. Remember, the anti-side has been working long and hard, passing laws and trying to make more. Anything more than minimum compliance is self-regulation. Y'all take care. Bye.